My name is Jillian. I am one of Campco's community managers. With us this evening, we have Josephine Wolf from Clemons, Richter, and Reiss here to review the collections process within the state of Pennsylvania. She has a presentation ready for us. If you have any questions during the presentation, please feel free to unmute yourself then or utilize the chat feature, and we would be happy to answer your questions. With that said, I'm going to turn it over to Josephine to get started.
Hi, good evening, everyone. Thank you so much for joining us. I do see some familiar names to me, which is fantastic. For those of you that I don't know, I would love it if you could place in the comments what community that you are joining us from and where you're located. I'd love to hear it. As Jillian said, my name is Josephine Wolf. I'm an attorney with the law firm of Clemons, Richter, and Reiss. Can everybody hear me okay? All right, I see some nodding heads, which is fantastic. Can everybody see my PowerPoint?
Yes.
Awesome. So I do have to apologize for the PowerPoint. I did a little test run and it wasn't letting me advance the slides. I think it's an issue with I have two screens. So I'm just gonna show it to you this way. Okay, awesome. So all right, so let me shout some of you out here. We have Stacy from Gable Park Woods in Lancaster. We have Charles Marino, Jackson Heights Condo in York, Bridgeview Place, Jonathan Gave, Philadelphia, Mary Rakin, the Highlands in Berwyn. We have Gamal Amer with Carriage Run Phase 4 in Skippack, PA. Gary with Summit Ridge Condo Association. We have Larry with Bluestone Creek. Is that HOA or condo, Larry? We have Rocco from Holiday Village East in Mount Laurel, New Jersey. We have Joe Bacon, Green Tree Summit in Philadelphia, PA. Larry says it's Bluestone Creek HOA. Awesome. Okay, anyone else? Feel free to shout out where you're from. Okay, awesome. So let me just get started on the collections. I'm sure because you're joining us, you either have some issues with collections in your own community. Currently, you've maybe had some issues in the past, or you're just pre-planning ahead for potential issues in the future. Regardless of your intentions on joining us, I really appreciate you being here, and I hope that you get some important information out of this presentation that I'm going to give. Okay, let's get into it. So the number of community associations and condominium associations in Pennsylvania is over 7,000, which is pretty staggering. The number of Pennsylvania residents living in community or condominium associations is 1.4 million, again, a staggering number. And even more staggering is the anticipated or the estimated amount of assessments paid each year, $2.7 billion. So when we're talking about assessment collection, of course, it's a form of debt collection, but in reality, it's necessary for you to be able to properly run your own communities. And I like to, try to explain it in the sense that you all have budgets in your community and, you are anticipating actual budgeted for expenses, right? So if an owner isn't paying their assessments and their dues, then you're not able to, actually get all of your obligations paid for that year. So it is pretty serious. And it's, something that should certainly be taken care of as soon as possible and monitored, on a daily basis. So I'm sure it won't surprise you, but by 2040, the community and condominium association housing model is going to be the most popular form of home ownership. Can any of you kind of guess why that is? Give some reasons for that. You can throw them in the chat. You can jump in via audio. Anyone? Do we have any municipal board of supervisors on here? Any zoning hearing board members? Okay. Well, one of the biggest reasons is because it is really enticing for municipalities because your community and your condominium associations take care of, in most situations, take care of all of the common area, open space. So communities that are not homeowners associations, the township or the borough or whatever municipality that you're in would then have to come in and take care of some of those common facilities, the biggest ones being stormwater management. And interestingly enough, stormwater management is what actually kind of jump started this housing model in terms of HOAs and condos. All right, so in terms of collections, we are going to go through, you know, a pretty significant amount of topics here. And, you know, I could give a full day presentation on collections, probably multiple days, because everything is pretty nuanced. And the collections does kind of bleed into other areas of the law as well, which I'll get into. All right. So the first thing that you want to do as a board is you want to see if you have a collection procedure in place. So this would really make sure that your procedures in terms of assessment collection are going to be consistent across the board. You know, I do have some buzz questions to ask, and some of these questions may actually be answered in your own governing document. So when you are putting together a collection procedure, I certainly recommend that you consult with your own legal counsel to make sure that what you're proposing is actually consistent with and not contrary to what's already in your documents. So you want to check, you know, do your documents allow for late charges? You know, the Uniform Planned Community Act, Uniform Condominium Act do allow for late charges. However, some documents actually will set forth a specified amount of the charge. I've seen some documents that will say 5% of the overdue assessment is the max late charge. So you want to make sure that the late charges that you are actually assessing on these accounts is authorized. And it helps if you're in a court proceeding to be able to show a judge a procedure and say, we followed our procedure. The unit owners know this is the late charge. The unit owners know this is the interest. You want to make sure that attorney's fees and costs are authorized to be shifted to that delinquent unit owner. You want to make sure that you're working hand in hand with Camco to make sure that the notices are being sent in terms of the delinquency and the frequency, and, you know, just having a benchmark as to when an account is turned over to legal counsel for collections. Any questions or comments on considerations of a collection procedure? Okay, seeing none, I'm going to keep going. So the collection procedure is essentially adopted the same way a rule and regulation would be adopted. You want a formal board resolution. You want, you know, obviously that would have to pass by majority of board vote at a board meeting and make sure it's followed. I can't stress that enough. Again, you want to certainly make sure that you are consistent with what Camco is doing and what legal counsel is doing as well when it comes to collections. Okay. Now I like to sprinkle these comics in here a little bit just to kind of lighten the mood a little bit, but unfortunately, Tony isn't going to be an acceptable method of collection nowadays. Right. Okay, so one really interesting right and power that you have when it comes to assessment delinquency is you can suspend privileges. So the Uniform Planned Community Act and the Uniform Condominium Act were amended in 2018 to specifically permit you as the board to suspend privileges. Now you have to, you know, if your community is, you know, older than being formed in 2018, you have to consult with your documents. Sometimes your documents will have their own requirements in terms of the notice and in terms of the length of a suspension. So some of the privileges are obviously the right to vote, the right to serve on the board, the right to serve on committees, the right to use recreational facilities, right of access to common elements, and other amenities that you may have, and the right to make exterior alterations. And the caveat with the exterior alterations is it would have to be something that is essentially going to be not emergent. You know, it's going to be an aesthetic upgrade, so to speak, and not something, you know, that is an issue that's causing damage. You could be held liable if something like that is rejected. How many of you have pools or a clubhouse or other enticing recreational facilities? Okay, I see Vicky has her hand up. I see some head nodding. Arlene has her hand up. Awesome. So pools and clubhouses are actually really great incentives to get people to pay. I'm sure Jillian can tell you when we get closer to that pool season, all of a sudden you get more, you know, more phone calls and requests for balances, and you get some of those smaller balances paid. Are they going to have an impact on, you know, the larger delinquencies? Probably not, but at least they will help you not get to those larger delinquencies. So it's a really good tool in terms of suspension of privileges. Have any of you suspended privileges recently? No. Okay. Well, the important thing to note when we're talking about suspension of privileges is that the law requires you give notice of the suspension, and that unit owner does have an opportunity to dispute the suspension by requesting a hearing before the board. So you want to make sure you have all your ducks in a row before privileges are suspended. And your legal counsel can certainly help with making sure that that language goes out and the notices are given correctly. Okay. If any of you have worked with me, which I know some of you have you ever heard me talk about the Fair Debt Collections Practices Act? I'm sure you have. Yeah, I see some heads nodding, and that's okay. Unfortunately, as an attorney, I am considered a debt collector under this federal law. And what that means is that I, essentially have to make sure that I'm abiding by all of the requirements that are in the Fair Debt Collections Practices Act, which includes sending what's known and commonly referred to as a 30-day demand. So I have to have that requisite warning language in there, which permits people to dispute the debt essentially. I have to have some required disclosures. I obviously can't collect anything that isn't legally enforceable. And then in terms of the communication methods, I am limited. So I am, we, at least in my office, we don't make cold calls and we don't send, what I call cold emails to unit owners. We wait for them to reach out to us first and then we'll respond to them. And the reason for that is because we can't confirm that that's a private phone number or a private email. The information could certainly get out to a third party and then we could be held liable for disclosing, confidential and sensitive information.
Josephine,
So,
we do have a question in the chat, if you don't mind me
yes.
jumping in. Does the letter inform meeting with the board privilege?
So if this is in terms of the suspension of privileges, then yes, you want to essentially note that your account balance is delinquent, your privileges are suspended, and you want to specify what privileges you're referring to. And then you want to make an indication that, the unit owner has the right to dispute the suspension of privileges by requesting a hearing or a meeting before the board within a certain time frame. We typically say 10 days. We find 10 days to be reasonable in consideration of the mailing time. I don't know if that answers the question. If it doesn't, please send a follow-up in the chat. Okay, when it comes to the Fair Debt Collections Practices Act, one of the biggest things that we're faced with is trying to make sure and really ensuring that we can prove every single charge on the account. So, it might seem frustrating at times if we're asking for a lot of backup, but we're just essentially really trying to protect ourselves and our licenses. And we're also trying to protect you because we don't want, a debt collection case to turn into, a Fair Debt Collections Practices Act claim. So an example of that would be we need backup for all fines, which would include the notices sent. And I'm sure all of you know that when you do assess a monetary fine, just like the suspension of privileges, you have to give notice of that fine and an opportunity to dispute the fine by requesting a hearing before the board. So that's one thing that we check on in terms of fines. If there's any kind of maintenance chargebacks, we want to make sure that the unit owner was given notice and that it's authorized in your documents. Now, some of your documents, and when I say documents, I should explain that I'm referring to your declaration or CCR, your bylaws or code of regulations, and then your rules and regulations. If it does authorize a chargeback, for example, if a unit owner fails to, maintain the exterior of their property, you give them notice you're in violation, you follow up and say you haven't, weeded your garden bed, for example, and it's a violation and we're going to do it at your cost. And here's how much it's going to be if you don't do it within a certain amount of time. So once that's done and once, the work is actually finished, assuming you have authority to do it in the first place, then you have to send a notice. This is how much the final cost was. It's going to be posted to your account. So that's what we look for. And Jillian and her team at Camco are really fantastic when it comes to the backup for everything, which is very helpful for us. And, the Vanica platform and the Vanica system has been a game changer for us because we're not having to continue to go back and forth with your community manager and ask for backup. We're able to actually go in, pull the notices ourselves, and pull all of the information, which, you know, is helpful for everybody because we're able to do our job quicker. We're not having to take time, you know, really precious time away from your community managers because they have enough on their plate as it is. So anyone have any questions about, you know, what we look for when we're looking at an account? Okay. So what I didn't mention is we want to make sure we go back to a zero credit balance, obviously, so we can prove every single charge. Okay, I will certainly, you know, move on. I kind of went through all of this already. The miscellaneous charges we look for, if there's a special assessment, Camco is going to have all the records of that, which is really helpful. Okay, so this obviously isn't a collection letter that we would send out, but I've seen other people send things out like that, which is fascinating. Okay, so Gary did pose a question in the chat. Is an email a valid form of notice or must it be snail mail? If snail mail, should it be registered or certified? So Gary, I'm going to tell you to take a look at your declaration or bylaws. There's going to be a notice requirement and a notice provision, and that's going to tell you the answer to your question. So most of those notice requirements do require, you know, US regular prepaid mailing. You know, some communities do have people who essentially sign authorization for notices to be sent via email, but at the end of the day, it has to be consistent with what's in your declaration or bylaws. I most often see the notice provisions in your bylaws, but sometimes they are in the declaration. So I would take a look at that. But I'll tell you the vast majority of cases, the notice has to be sent via regular mail. That doesn't mean it can't be sent both ways if the particular unit owner has provided their email address for notice purposes, which is what you can, it's my understanding that owners include all of their information and their preferred method of contact when they create their Vanica accounts. Okay. All right. So the Consumer Financial Protection Bureau did come out with a debt collection, model form, that 30-day demand I was talking about. They came out with essentially a model. So this would give us safe harbor as a debt collector to the extent, you know, that we have all the required warnings. You've probably seen copies of these from any of your, you know, legal counsel that you utilize. But what it doesn't protect us from is if this number is not legally enforceable. So it's not a complete protection for us, but it does at least ensure that we're giving all of the required Fair Debt Collections Practices Act notices. Okay. Anyone have any questions about the Fair Debt Collections Practices Act? Okay, great. All right, so let's move on to an association lien. This is probably one of the most confusing parts about association collections because the Uniform Condominium Act and the Uniform Planned Community Act, and I should ask, is anybody here representing a cooperative, a co-op? I don't see any hands. Co-ops are pretty rare in Pennsylvania. We mostly see them in Philadelphia and in Pittsburgh. We do represent a couple here, so they're not, you know, non-existent in our state, but, you know, they're certainly rare. So I thought I would ask because I am going to reference Uniform Condominium Act, Uniform Planned Community Act. There is the Cooperative Act as well. And all the three acts generally are pretty identical in terms of the provisions. There are certain nuances though. So I'm going to stick with my condominium and HOA references here then. All right, so the statutes do indicate that the association does have an automatic lien for unpaid assessments, fees, and charges due to the association. And the way that the statute is written is that lien can't be just filed with, you know, with the county. It can't be filed with the Worthonetary's office or Office of Judicial Records. The way the statutes are written is that you have to file a complaint to essentially get a judgment entered to enforce that lien. And really what the legislature has decided is that unit owners should be entitled to essentially an opportunity to dispute the debt in the court system. So the way that we, you know, the way that we enforce the lien is to file a complaint, whether that's in magisterial district court or whether that's in common pleas court, which I'll get a little bit further into, and seek a judgment. And then once that judgment is entered, that's what we can use to try to collect the debt. And again, I'll get into those execution methods a little bit later. So, you know, the lien can't necessarily be used to try to go through with those execution methods because there are court rules and procedures, excuse me, in place for that. So, you know, one of the most common questions I get as an HOA attorney is, why can't we just go ahead and file a lien? And I'll tell you that that's not the proper legal method to do it. And it could certainly put your association attorney in hot water in terms of a Fair Debt Collections Practices Act, because you're not following the statute in terms of how you are supposed to collect. All right, so I kind of got into the complaint. Let's get into the court system in Pennsylvania. Is anybody familiar with the court system? Do you work in the courts? Okay, Kenneth raised his hand. So this maybe won't be news to you, Kenneth, but I'll go through it rather quickly. So in Pennsylvania, we do have what are referred to as magisterial district courts in the county. So this isn't including Philadelphia. I'll go through Philadelphia procedure pretty quickly after this. In the magisterial district courts, there are local district courts within your individual jurisdictions. There's a $12,000 limit in terms of what a judge can award as a money judgment. Those courts are limited to hearing, you know, money judgment cases or landlord-tenant cases, essentially. So what those judges aren't authorized to do is to enter equitable relief, which is something that only the higher court can do. But because we're talking about assessment collection, I'm not going to get into equitable relief, because what we're really seeking when we're trying to collect the assessments is going to be that money judgment to enforce our automatic lien. So again, the magisterial district court is, you know, the lower court. It is sometimes referred to as small claims court. Have any of you had the opportunity to go to a magisterial district court hearing? Kenneth, okay. Anyone else? I see Vicky shaking her head. Okay. So it's a little bit more, well, in most cases, it's a little bit more informal than, you know, your higher court. A lot of times the magisterial district court judges will kind of try to cut to the chase and see what the true issue is and try to get the parties to make an agreement. So it can be helpful in terms of trying to resolve the cases. So moving on to the common pleas court, which is the higher court, that court essentially is going to be where you need to file if the balance due and owing is $12,000 or more. So that's going to be in, you know, the county seat, depending on what county you are. In Bucks County, it's in Doylestown. In Montgomery County, it's in Norristown. In Delaware County, it's Media. And in, where else am I missing? I know. In Chester County, it's Westchester. So, you know, Philadelphia court system is a little bit different, but not too different. So Philadelphia, they have the municipal court. There's only one Philadelphia municipal court location. It's in Center City. It's not far from City Hall. It's, you know, a block or two away from City Hall. And then, you know, their higher court is common pleas as well. So the only difference is really in the name and the fact that there's only one central municipal court location, whereas in the surrounding counties and throughout the rest of Pennsylvania, there are magisterial district courts, but they're right in your backyard, which is more convenient for you if you ever have to be in front of the magisterial district justice. Okay. Any questions on judgments, on the court system? Okay, seeing, Kenneth, do you have a question? You're on mute. Kenneth, you're on mute. I don't know if you can unmute yourself or not. There you go.
The decision in magisterial district court can be appealed within 30 days. Then it jumps up to common pleas court.
Yep, absolutely. Yeah, and going off of that as well, Kenneth, if there is an issue with service at the magisterial district court level as well, I'm sure you know that you know, the magisterial district court, the service is either by constable or it's by certified mail. At common pleas, we have a little bit more service options with leave of the court, obviously. If there's a difficulty getting service, if somebody's avoiding service. Awesome. Okay. Well, thank you for that. I appreciate it. All right. So let's get into the executions. All right. How many of you have dealt with a personal property levy execution in your community? Okay, Gamal's raising his hand. Anyone else? Okay. Well, what a personal property levy is, it can be done at either the lower court, the district court level, or it can be done at the common pleas level. And it essentially is inventorying, excuse me, somebody's personal property and subjecting it to a public sale. So, you know, what that does is essentially a number of things. It really does get the delinquent unit owner's attention. And, you know, oftentimes it does result in some kind of payment plan negotiations. Now, you know, I could talk about personal property levies all day, but, you know, what I like to refer to it as is it's essentially a lawful method of, you know, I don't want to say harassment, that's too strong of a word, but it's, you know, a lawful method of sending the constable, if you're at the district court, or the sheriff out at the higher court, to try to continue to collect on your underlying judgment. And nobody wants their neighbors, or I shouldn't say nobody, the vast majority of people don't want their neighbors to see the constable or the sheriff coming back and forth to their property multiple times. So sometimes that's enough to get people's attention. Other times the constable or the sheriff is going to levy on a vehicle. They do have the capability of running the vehicle information and seeing who it's registered back to, which can be, you know, really helpful because, again, nobody wants their vehicle sold. I've had a couple occasions where, you know, there are some, you know, unique, I should say, collections that are in plain view that the constable or the sheriff have levied, and it resulted in a cashier's check the next day. I've seen China collections, gun collections, you know, and that's enough to get people's attention. Sometimes it doesn't work and they just ignore you, and then you're going to have to go to the next, you know, the next step. But, you know, it is usually enough to get their attention. What I will say is that we rarely go through with those sales because sometimes the property levied is just not worth anything. I just had an inventory report come back, and I will not name the names of anybody involved. But the one piece of property that was inventoried and levied upon were blinds, like window blinds, because I guess they had all the blinds drawn, and that was the only thing. They weren't answering the door. That was the only thing that I won't even say if it was a constable or a sheriff, but that was the only thing that the constable or sheriff could see. So I got an inventory back with a sale scheduled for blinds. So as I'm sure you can imagine, we canceled that because, you know, that's not going to be worth anything. But it really is a case by case analysis as to how to proceed. But, you know, ultimately, if you were to go through with the sale, you would want to try to get some interested bidders there, but again, it is difficult to get people interested in it. And if you don't have any bidders, then essentially the association would take the lot, all the property, for cost. So you have to pay the sheriff or the constable cost to come out and have the sale. So you would take the lot for cost, but you'd be responsible for the removal of it. You'd be responsible for the storage of it. And sometimes even that cost outweighs what you can sell it for and credit back to the judgment. You know, I've seen some of these not go very well, not ones that I've handled personally, but ones that I've heard about. I had a client who, you know, did a levy before I took over representation of them. They took 5, you know, for lack of a better word, junk vehicles. And by the time they were able to sell them, get the title transferred involuntarily, they actually were out money as opposed to making money because of the towing, the storage fees, and then on top of that, the cost to involuntarily transfer title to a vehicle. So again, case by case basis. The idea with the personal property levy is that you really don't want people's stuff. You want them essentially to contact you to try to make payment arrangements. Okay, and then getting into the next execution method, it's a bank account garnishment. So this can only be done at the higher court level. The district court isn't capable of doing the bank account garnishment. You have to do it at the common pleas, the higher court level. There are some exemptions to a bank account garnishment. Some accounts are exempt by law, which would include any account getting a governmental benefit. If you know, it's a joint account and there's married individuals, but only one of them is a judgment debtor. And ultimately the way it works is that the sheriff serves the bank then answers what's called interrogatories, lets us know how much is in any account that was, that was going to be garnished. Essentially, a hold's placed on the account, the owner, the account holder is notified. It can be successful sometimes, but it is certainly a gamble because, for all of those that I've gotten back that had significant funds in the account, I've gotten back just as many where there's, minimal to negative balance on the account. And the way that you figure out the banking information is you have to work with Camco to see, have they paid by check recently? If so, do you have a copy of the check? And do we have essentially the place that they bank with? It's really as simple as that. Anyone have any questions about levies or garnishments? All right, and I do see a comment here from Rocco. He asked, are you referring to foreclosing property? Yes, I am. So I'm going to get into that next, and you'll see it right here on my next slide. For just rent garnishment very quickly, for properties that are tenant occupied, if you have that tenant name, ideally you're going to have a copy of the lease and what they're actually paying in rent. We can do a rent garnishment, and that's a formal process that we can work with you to get to. That has to be done at the higher court. Again, it has to be done at the common pleas court, and it's served by the sheriff on the tenant. Okay. And then, some of your governing documents, or if you have a leasing amendment, for example, especially one prepared by my office, because we always love to include language permitting the association to informally garnish rent. And we've been successful in doing that. And really what that means is that your documents have language that says if a unit is rented and landlord is delinquent, the association can serve notice on the landlord that if landlord doesn't pay the balance, which within X amount of days, say 60 days, then the association intends to seek rent garnishment from the tenant, and the tenant would pay the association directly. So that's really, really powerful language, and it's certainly worked in the past for us to get some accounts current. So it's a really good tool to have in your arsenal if you are thinking about a leasing amendment. You want to include language like that in there. Some governing documents, some declarations already have that language. So make sure, you take a look and see what's in your documents and see if you're able to do that informally without having to get a judgment, without having to file the garnishment paperwork and going through, the more formal, time-consuming and expensive process. Has anyone ever done an informal rent garnishment? Okay, Sharon and Tim are raising their hand. That's great. It can be a really useful tool. So I always like to bring it up when we're talking about rent garnishment specifically. Yeah, and I mean, I should say that the formal rent garnishment really is only good for one rental payment. So in order to continue that, we then have to file a petition with the court. And it does require that the tenant respond to those what we call interrogatories, which is really a fancy way of saying questions that are posed in terms of, if you're paying rent, how much are you paying per month, excuse me. If they don't respond to it, then you have to consider what the sheriff or the constable, I'm sorry, it would be the sheriff here. The sheriff reported back in terms of attempts to serve. You could try to get alternative service on them, but I would say at that point, it's really not worth the time and effort if the tenant's not going to be cooperative. Okay. So as Rocco referenced, I am going to get into association foreclosure. And again, this is something that I could talk about probably for multiple days because it is very complicated and it's very nuanced. And it really is specific to every single case as to whether or not it's appropriate. And again, that can only be done at the common pleas, the higher court level. Each sheriff's department and each of your respective counties has very particular and specific requirements in terms of what needs to be filed and what paperwork needs to be provided to the sheriff. It is pretty specific. And luckily some sheriff's departments have in the recent past adopted forms, a checklist, so to speak, which is very helpful for us practitioners to make sure we're following the procedure. So not only is, the foreclosure difficult in terms of getting all the paperwork together, filing it, but it is expensive. in Montgomery County, the sheriff's deposit, which is really just the fee for the sheriff to advertise, list the properties for sale, and serve, is $4,500 for a money judgment. In Bucks County, it is $2,500. In Delaware, I believe it's $3,000. And Chester County, it depends on how long your legal description is, but it's anywhere from, I think, $3,000 to $5,000. So it is a very expensive, and that's just in terms of, the actual sheriff's cost that you have to pay. And it does require that there is sufficient equity. And the way that we have to figure that out is by getting a title search, seeing what liens are superior to the association, because the association does have what's referred to as a super lien, but the association isn't at the top of the totem pole. So your lien still comes after the first mortgage. It comes after any, unpaid taxes or governmental liens. It comes after Department of Revenue liens, IRS liens, sewer rents. Those are typically things that I see. Obviously, unpaid taxes, which I think I said. So the association's kind of third, so to speak, on the totem pole. So, one of the questions I get a lot as well is, well, how do we know how much they owe on that first mortgage? And the answer is that you don't, unless you subpoena the records, which again is, it's not a difficult process, but it's a little bit time consuming in terms of issuing a third party subpoena to the mortgage company to them respond and let you know to the penny how much is due and owing on the mortgage. Now, sometimes when we're trying to find that out, we get lucky and we see that maybe in the recent past, there was a mortgage foreclosure filed. And when that's filed, all of that documentation is going to be public record. So we can, for a fee, of course, we can pull that original complaint or even an amended complaint if that exists, and at least pinpoint it at a point in time how much was due and owing on the mortgage. So that can be a really good tool to try to gauge, do we think that, there is any equity here? So those are really the big considerations when it comes to foreclosure, because if there are no third-party bidders at a sheriff's sale, then you would essentially take title to the unit for costs, and you would still take title subject to everything that's above you in that totem pole that I described. So the way it would work, and I have certainly seen it work this way, is there's no third-party bidders. The association gets a sheriff's deed to the property. Then you would really have to either negotiate with the mortgage company to try to, come up with a payment schedule, which, as you can imagine, mortgage companies typically are not going to be very receptive to that. Or you can resell and try to pay the mortgage company off in the process. So that's, the consideration in terms of, do we think there's equity and why that's so important? Because I know it's really enticing that you do have the right to foreclose, and, and it's stated right in the Uniform Condominium Act and Uniform Plan Community Act that the association's lien can be foreclosed in like manner to a mortgage foreclosure. So it's very enticing, and it's an incredible tool for collection of these larger debts that you may have, but it has to really be utilized carefully. And you have to make sure you're doing all of your homework, because at the end of the day, you as board members do have a fiduciary obligation to act in the best interest of your community. That's why you have professional management. That's why you have legal counsel and other professionals assisting you. So you really want to lean on your association's attorney to guide you in this process, and make a recommendation as to, is this risky? Is it, worth the risk? Because in some of these situations, if an association's considering foreclosure, typically this person is behind in every other aspect. So, mortgage foreclosure proceedings might be looming, and we'll get into that a little bit later as to why it's important, to monitor those types of proceedings. But ultimately, association foreclosure is really the last and final resort for assessment collection. It's not something I jump on immediately. I like to try, the less significant methods of execution before I'm going to foreclose. Unless, there's always a caveat to everything and to every case, unless there's a significant history with this particular individual and that foreclosure is the only way to get them to pay up. Another consideration that, you know, you may not think about when it comes to foreclosure is if, as I stated before, if there's no third-party bidders, if the association ends up with title to the property subject, you know, to the sheriff's cost you already paid out and subject to all of the superior liens, if the unit owner holds over, if they don't voluntarily leave, then it's your obligation and your responsibility to get them out. And that requires what's called an ejectment action. That has to be filed at the higher court, and you know, the writ of possession on an ejectment judgment is a little bit more of a complicated process. It's nothing that we haven't done, but again, it is time consuming and it can get a little bit expensive depending on if the unit owner tries to fight the ejectment action. Sometimes they'll just try to sit tight until they're forced out because they're not having to pay a mortgage during that time. They're probably not paying other obligations like taxes, sewer rents, all that. So, you know, those can be complicated situations. Has anyone had to deal with an ejectment in their own community? No? Okay. Well, consider yourself lucky. I hope you don't have to. But yeah, it's not a fun process. And one of the questions I get when it comes to communities being in that exact situation is, well, why can't we just file landlord-tenant action, get them evicted? And the reason is because you don't have a landlord-tenant relationship with a holdover unit owner after foreclosure. So the third-party bidders at sheriff's sale also would have to take on that obligation. If they purchase a property that is occupied and the occupant does not voluntarily leave, then a third-party bidder is going to have to do that too. So has anyone been to a sheriff's sale? A foreclosure sale? Okay, Sharon, do you want to comment on what your experience was? You're on mute, Sharon. Can you unmute yourself?
Okay, I guess I did
There
it.
You're good. I can hear you.
Well, this wasn't actually at the community where I live. I was a property manager for 25 years. So I was at a sheriff's sale for a property that I was, under my management. And it's interesting. This was years ago. I went with the president of the association, and we thought we were prepared, that we would purchase the unit if there was no other bidders, but there were many other bidders because it was a good property. And we ended up doing okay. The association got all their money in the end, but it was interesting to sit and watch the guys that come that are frequenters of the sheriff's sale process. They knew exactly. They had their money, they had their cash, with them, and they knew exactly what they were doing. So it was interesting.
Yeah, thank you for sharing. It is very interesting if you haven't been, if you unfortunately do have to go through it as a community. If my office represents you, we are always willing to have board members come and see what the process is. It's fascinating. I mean, it really is, essentially an auction. It's an auction. The sheriff's department is going back and forth with bidders, and they have to bid within typically $1,000 increments, and sometimes it can be very competitive. And as Sharon mentioned, it really is the same people you see every single month. Some of them are real estate professionals, some of them are attorneys who on the side have a house flipping business. Some of them are going to be, contractors. So, but they all know each other, and the sheriff's department knows them, and they get to know the mortgage foreclosure and the association attorneys. So they kind of swarm you when you come in and try to get information out of you. But, it's important for our purposes not to disclose any information that isn't already publicly available. A lot of the questions I get is the person living here? My answer is always no comment. I don't know, because you don't want to, create any expectations or disclose any information that you shouldn't be. But it is an interesting process. Tim, I saw you were raising your hand.
Yes, hi. Can you hear me?
Yes.
Great. I was wondering what would establish the starting bidding price? There must be some metric they use to come up with that. right?
Yes, yeah, it is. So I actually tell everybody what the upset price is. The upset price is the start bid. And what that is it's your judgment. So it's the association's judgment plus the cost. So if you had a 10,000, say we're in Montgomery County, you had a $10,000 money judgment and the costs were 4,500. I would, which is what the Montgomery County cost is. I would say that the upset price is $14,500. The attorney on the writ bids costs. And oftentimes I will have to announce that this property is sold subject to a first mortgage. So that's my job, is to spout all of that. So I set out, what the upset price is. Again, it's the judgment plus the sheriff's costs. And then I let everybody know if it's subject to a first mortgage. And then I say the attorney on the writ, which is really the attorney representing this plaintiff, you as the association, is going to bid cost. That's the floor. That's where it starts. Yep. And then the bidder will say, okay, I bid 12,000, and then it'll go 13, 14, 15, 16. I mean, they usually go in either $500 or $1,000 increments.
And there would be nothing tantamount to a reserve. In other words, there's no costs that are involved, whether by the first mortgager or any other subsequent people that would say, oh, no, that's not enough. It's just,
No. I mean, there's certainly case law. So after a sheriff's sale, you can file what's called a petition to set aside the sale. You need good cause. And there's case law, I think, in terms of what you're referring to, whether or not, the bid price was grossly, under, you know what I'm trying to say.
Yep.
So, that is actually considered in conjunction with whether there's a first mortgage and what liens survived the sale. So the court, in determining whether or not, a bid price was grossly inadequate, is the phrase that the court uses. It depends. They also include, the first mortgage and any other liens that survive it. So even, you see, I just saw a headline that said, woman owed $2,000 and association foreclosed and it sold for 50,000. And that's what the headline, the news headline said. But what, they're not considering is that, well, it's sold subject to a $15,000 tax lien and it's sold subject to a $400,000 mortgage. Excuse me. So, those are things that the court is going to consider if somebody challenges if the bid price was inadequate.
when somebody wins that bid, are they responsible for any, like the outstanding mortgage as well as the the purchase price?
Yeah, they would be responsible for any first mortgage, and any governmental liens and taxes that survive the sale.
Do they know that going into that?
They should. Yeah, it's caveat emptor, it's buyer beware, so they should certainly know that. And, as Sharon can probably indicate, I'm sure she realized, this isn't a lot of people's first rodeo. Some of these, professional bidders, so to speak, are attorneys, so they will do their own title searches and they'll have the information. They get kind of savvy to what to look for in terms of bidding on a property.
You know what, sometimes a shame is that the person, in my case, the person did not owe that much money, and the sheriff's sale was initiated by the city of Philadelphia for back taxes that were owed. And it wasn't that much. It was, for a couple of years. And then what he owed the association. There was no mortgage. And after the sale, the purchaser, in my case, was a guy, the contractor that buys and flips. They came like the very next day with the sheriff to get the guy out of the apartment, and that in and of itself was really upsetting for me as a manager.
It's very upsetting. Yeah, I mean, it's very emotionally charged. And especially if the unit owner shows up to the sheriff's sale and they watch their property essentially be competitively bid. It's very emotionally charged, but at the end of the day, they get notice of the sale.
Right.
They have to actually be served in person or otherwise by court order. So it's taking the emotions out of it is very hard, but at the end of the day, they get notice after notice that this could potentially happen. So, yeah, I mean, I had at one of my sales, I had again, no mortgage, minimal taxes owed, like a ton of equity in this property. Frankly, it was like a flipper's dream. It was, you know, a condominium, but it was actually more so a townhouse. It was meticulously upkept. You know, it was one of those cases where it was shocking that they let it get this far, really. And she came to me as the bidding was happening with a handwritten agreement of sale. And I just said, that's not a cashier's check. I can't accept it. But you know, those situations are not easy. But at the same time, you know, you have an obligation to try to collect outstanding debt. And unfortunately, it sometimes takes getting this far, which is a shame. But it's just really an unfortunate reality of your board membership. And it's an unfortunate reality of the association practice in and of itself. You know, the collections and enforcement aspect is certainly the most difficult and emotionally charged, and it's the most litigious as well. So, you know, this is one of the areas that I've somehow strived in over the last 10 years, and I can't seem to get out of it because it's part of the practice. And I love the alternative, you know, the general business of the association practice. I love preparing your amendments and resolutions and reviewing your documents. That's really, you know, what I love to do. But on the flip side, I've learned I'm pretty good at the assessment collection and enforcement and litigation that comes with it. So here I am, but I am here to help. All right. So the foreclosure, and let me see. Leontine said, did you say the bidder holds responsibility? Yes. In terms of any superior liens, the bidder would be responsible for those. Correct. And then we would obviously get paid from the sheriff's sale, the judgment amount plus the costs. Okay, so I'm going to try to move. I really only have a few minutes left. So instead of going through, you know, mortgage foreclosure, short sales, tax sales, bankruptcy, you know, these are all situations that your association attorney can help you get through and navigate. But does anyone have any other questions, any stories that they think, you know, everyone else would find helpful or enlightening?
Could I just add one thing?
Sure.
Piggyback off what we were just talking about. It can be gut wrenching to see somebody go through this, and can only imagine what it must be to go through this. But we find ourselves as oftentimes neighbors as well as board members, but people with a fiduciary responsibility. I am always concerned, or I always hope that that somehow we can educate these people if they had any idea what they're about, the situation they're going to find themselves in, that they might work with the association or whoever the entity is to try to resolve this before it got to this point. So I guess for our purposes, like for the association purposes, is there often conversations with the people involved to let them know exactly what they're going through, what they're about to go through if they don't somehow make an arrangement, if they can, to resolve the matter?
So
Well,
I'm sorry, go ahead, Sharon.
as a manager, believe me, I did it every which way possible. Personally, by mail. I mean, sometimes it's, you know, the person suffers from mental illness, and there is no reasoning with them.
Right, sure. And I know that that's always been at the forefront of our board meetings, is trying to work with the people every way possible, trying to educate them or just let them know that this is the last thing we want.
Right.
But, and that, you know, at the end of the day, we're up against it too. We have to make a decision to do nothing or to do something. And, you know,
Right.
you're doing something for the entire community. But yeah, it's difficult, but I just always hope that there's adequate communication to let people know that this is going to happen, and if there's any way to try to resolve it before it does, be there in their best interest, not just ours.
Right, yeah, and it
and-
really depends on the community, Tim. I mean, some communities will ask to meet with delinquent owners. Oftentimes they don't show up. I am sometimes asked to say, if you don't pay, we're gonna go through with X, Y, and Z. And I'm hesitant to do that only because then it's showing our hand. And for an example, bank account garnishment, for example, they could then move all their funds. So I try not to show my hand, or with a foreclosure, they know it's coming, so they're avoiding service and making all of our lives more difficult and expensive, frankly. So depending on the circumstances, you know, if it's appropriate, I will show my hand, but I try not to.
At what point is the board, the HOA board member subject to the Fair Debt Collection Act requirements? For instance, what kind of a communication from the board would require the same notification that an attorney would make?
Well, you'll be happy to hear none, because you are collecting your own debt. So you're not a debt collector in the sense of the Fair Debt Collection Practices Act, because it's your debt that you're trying to collect. For me, I am engaged to collect the debt of a third party, you. So I'm a debt collector, but as board members and as a board in general, you are not considered debt collectors under the act.
Is it advisable for board members to discuss pending actions against involving collections in executive session rather than put them into a scenario where they have to be disclosed in minutes?
Yeah, of course. Yeah, you want to discuss any collections enforcement pending litigation matters in executive session, right?
Yeah, I would add, Josephine, any accounts receivable discussion should be in the executive session.
Yep, absolutely.
Josephine,
Rocco
Rocco
had his
Palmieri, can I
hand
ask a
yep, Go ahead,
question?
Rocco.
Yeah, hi, Rocco.
Maybe I'm a little naive about this whole process, but it always seems to me that there's most of the correspondence that takes place is through letters, back and forth, back and forth. There's very little contact directly with the delinquent owners. We've always been told by our attorney, well, you can't call them. We wanted to send them a letter. You can't do that. But it just seems to me, going back to what Tim was saying about educating people, we don't talk to anyone. It's all done by letters, and it seems like nothing gets done. I've been involved in this for a couple of communities, and it's the same thing in each community. It's all through letters, and I think that
Right.
that's a weakness.
Well, I will say, as far as my office is concerned, if somebody does call, and they ask to speak with somebody, it's mainly me that I'm calling them back. But when it comes to first communications, we don't cold call or cold email, as I mentioned earlier, because I can't guarantee that this is going to be either a phone line or an email that is private. It could be shared and I could put myself in hot water. But this doesn't prevent, you know, board members from trying to reach out directly. It's just the level of, you know, it's very uncomfortable, and a lot of board members, you know, prefer not to. And it can be dangerous, you know, depending on the circumstances. So
Well-
really, as a board, you can certainly decide if you want to try to make direct contact, because again, you're not debt collectors, you're not subject to the act. If you want to try to make direct contact and try to resolve it, you know, I've certainly have had boards that have done that and have been successful. But again, it depends on your level of comfortability, and you want to make sure that you're safe in doing that.
Well, we were told that we couldn't do that, number one. And number two, I've seen a number of cases where a $10 or $25 late charge has grown to a $2,000 delinquency, and most of it is just cumulative late charges, and nobody's ever spoken to them.
Yeah,
That's-
and in those cases, my office does look at every single account, and I would recommend against formal collection action in that kind of a case, because you have to think long-term, is a judge going to be willing to grant all of these attorney's fees and costs to collect late fees on late fees on late fees in the situation that you gave? So it really is a case by case and an account by account, you know, consideration. So we really do look carefully into accounts when we get them and make recommendations.
Thank you.
Rocco, from my experience and from what I was taught from my supervisor and, you know, previous managers, that if the account is in collections, then that is when we typically instruct them to contact the attorney directly. However,
Right.
prior, when you're reviewing your AR report, there have been times where the board's directed me, hey, so-and-so has, you know, $50 in late fees. Can you reach out to them about it? Or what's it for? Maybe we'll just waive it. So I think having that conversation prior to getting to the collections process is something that you might want to consider with your board members and your manager.
Okay,
Yeah,
thank
and
you.
Jillian, that's great, because to jump off of that, a lot of, you know, your community managers and boards have a policy that once it is in the hands of the attorney, they don't make contact anymore because there could be pending attorney's fees and costs that haven't been posted to the account. So you may not be giving an accurate balance as of that date.
We are running out of time, but we could take one more question. Do we have another question?
Yeah,
But
I
Charles has
do.
had his hand up.
Yeah, Charles Marino. We have, there's a condo here in New York, and we have a homeowner that basically hasn't paid since they moved in about 2 years ago or so. The condo fee, and our Camco and we have it in, it's called With Alexa, which I think is a collection agency of some kind. And the people that are involved, or the homeowner, claims that they didn't know it was a condo when they sold it, when they bought it. They bought it from a realtor in Maryland, and we're in Pennsylvania, just across the border. And so that's the sort of situation. And we're now up to almost $8,000 in assessments that are due. And we are in this collection status, I guess. So I'm trying to figure out where is that in the process of doing anything else? I mean, I think the board has kind of decided that we're going to wait until she sells or moves or whatever, because it's too difficult to get something else. Any thoughts?
Yeah, I mean, it's not a defense to say I didn't know that there was going to be assessments. Once you take title to a unit, you're obligated to abide by the declaration, bylaws, rules, and regulations. The declaration's a recorded document. They had record notice of it. So that's not a valid defense. And waiting until they sell, they could be there for the next 30, 40, 50 years. You have a 4-year statute of limitations. So I really don't recommend waiting until they sell either. If it's been 2 years and the unit owner clearly has responded and just said, too bad, I didn't know, I'm not paying it. That's, I think at least as far as I'm concerned, that's grounds for we need to take this to court.
Does the fact that it's in some form of collections, does that prevent us from going to court, or does that, or is it in that company's purview to take it to court?
I don't know. I'm not really familiar with the company that you stated. I'm not really sure, but you might want to touch base with your community manager to see where you are in the process, because some of these true collection agencies, they're not attorneys, so they can't actually file complaints. So any of our clients that I have seen who utilize, an actual collection agency, they will refer it back to us when legal action has to be taken. But that doesn't, allow me to file immediately. I still have to send a collection letter because I'm still subject to the Fair Debt Collections Practices Act. And I'm, taking it over as a new debt collector, so to speak. So I can't rely on any notices that they sent.
I also want to note that Camco has their own internal process as well, with the amount of letters and notifications that we send out prior to sending to collections. So for example, and Josephine, you can help me out here, there's specific language in the last letter that is pretty much telling them if you don't pay or contact us to pay, you're going to be sent to the attorney.
Right.
A lot of times the contracts that the collection agencies enter into with the person trying to do the collection, you basically assign all your rights to them to be the exclusive individual to deal with the debt, at least until you terminate their services.
Yeah, that's a good point, Kenneth.
All right, and Stacy, you had your hand raised. We can take yours as the last question.
Actually,
Hi, I'm Dee. I'm here with Stacy. I have a question, and I'm not really sure you're going to help, but I would really like to ask. So we have a house in our HOA that is in dire need of work, and they have been getting violation letters for over 2 years now. None of the work is done. I don't know about the fees. But from the outside, it is an eyesore to, and we're thinking as a board, like, hey, if you're trying to sell your house or you're trying to buy a house, that would be a deterrent for that house. What would, we had mentioned it to our manager, basically beyond contacting a lawyer to see what we do you have any suggestions of steps we can take beyond what they've already done?
Well, it sounds to me like you have an issue with a maintenance deficiency, which would be an enforcement issue. It would be a violation of your governing documents, assuming unit owners are required to maintain the exterior of their properties. So ultimately, it's a violation. You can respond to it by assessing fines and then going the collection route in hopes that, the assessment and then the collections will result in them, actually maintaining the property properly and, being in compliance with your documents, or you can take it the injunction action route, which would require, an action filed in common pleas court, which would essentially ask the court to require that they maintain the exterior of the property. You may also in your documents have an opportunity to engage in self-help when an owner is not properly maintaining the exterior. Oftentimes, when I see this in declarations, it's typically in, or the code of regulations or bylaws, it'll say the association contacts you, demands that you, bring your property into proper repair and maintenance within X amount of days. If you fail to do so, the association can do all the work that needs to be done and bill you back for it. Obviously, the more notice, the better in terms of what the proposal is, what the anticipated cost is, because once, you engage in self-help, you would then have to still collect the cost you're putting out. And I don't know if you have the budget to do that, because most communities, even if you're going to set that precedent and do it, you don't have the funds to do it in every single case that somebody's not going to maintain the property. So a lot of communities prefer to go, it's called an injunction action route. It has to be filed by an attorney at the Court of Common Pleas. And, ultimately you're asking a judge to tell them to maintain their property.
Stacy, we have our association has the requirement for the owners to maintain the exteriors. And we had a similar situation in our development. We did have to hire an attorney. We started at the magisterial district court level and a judgment was entered. It was appealed to common pleas. That court actually, after losing patience with the owner, ordered the association's own contractors to do the exterior work and then assess the owner the cost of that contracted work. When the owner chased the contractor off the property, we went back and got a contempt order assessing a $50 a day fine for being contempt of the prior order. But we did have to use attorneys.
Thank you.
Thank
Well,
you.
Well, thank you all so much for being here this evening. I hope you have a great rest of your night, and I appreciate your time and your feedback, and your questions were really helpful.
Josephine,
Thank
I-
you.
I hope you consider a collections seminar part 2, because there's
I
a
should.
I
Well,
can,
Jillian, let me know. We can
I
set
can
it up.
definitely relay that to our executive team, because we do host board roundtables monthly, and this is a very challenging topic with a lot of information. So I will relay that. And then if you have any specific questions that you can think of after this, or if you have any that weren't answered now, please send that to your manager, and they can get back to you once they speak with Josephine or the attorney that you have for your property.
Thank you.
Thank you.
All
All
right,
have a
thanks
great
everyone. Have
night.
a great night.
Bye-bye.
Bye.